Started. Welcome to this conversation about the IRS's recent reinterpretation of the Johnson Amendment. We'll get to hear more about that from our panelists in just a minute. My name is Joe Swimmer. I'm the Executive Director of Episcopal Parish Network. Really pleased to have you joining us today, and thrilled that we have almost over 300 folks who signed up for this particular webinar. We'll be sending out a link to the recording of this later, and please do share it in your social networks. I wanted to mention quickly, we have several more webinars that are coming up that may be of interest to you. Next Monday, we'll have an interesting conversation about innovative models in ministry, new and innovative ways of thinking about our ministry with Good Shepherd Austin and the Erie Episcopal Collaborative. And then the following week, we'll have an interesting session on personnel manuals. So something to whet the appetite for everyone. Also, please don't forget that March 3rd through 6th next year in Charlotte, March 3rd through 6th, 2026, we will be gathering the church for our 41st annual conference, and we look forward to welcoming many of you there. I'm so pleased to have this panel with us today. We are grateful for them lending their expertise, and I'm not going to say anything else except to hand it off to our board member and the moderator, Erin. Erin, off to you.
Thanks, Joe. I want to take a few minutes to frame our discussion today and explain why we are at this particular inflection point regarding religious speech. Starts in January 2017 when President Trump at the inaugural prayer service held at the Washington National Cathedral shared with a group of clergy before the service that one of his highest priorities was to get rid of and totally destroy the Johnson Amendment and allow our representatives of faith to speak freely and without fear of retribution. For over 70 years, the federal tax code was interpreted as preventing a charitable nonprofit, including churches, from participating in or intervening in any political campaign on behalf of or in opposition to a candidate for public office. While President Trump did not dismantle the Johnson Amendment in his first term, he did issue an executive order purporting to limit the Treasury's enforcement action against religious entities engaged in political campaign activities. But many argued that the executive order essentially maintained the status quo, reiterating what the law already says about churches not risking their tax-exempt status so long as they do not support a political campaign or candidate. Fast forward to August 2024, when a coalition of conservative religious groups, including some evangelical Christian churches, filed suit in federal court in Texas, challenging the constitutionality of the Johnson Amendment as it applies to religious speech. 1 month ago, the IRS submitted in that litigation an interpretation of the Johnson Amendment that permits, during religious services, speech about electoral politics when viewed through the lens of faith. The effect of this interpretation is that such speech is not seen as participating or intervening in a political campaign. While the case is still working its way through the judicial process, the question is whether the IRS's position in the Texas case actually changes anything legally and or practically for people who preach. We have seen headlines suggesting that this position constitutes a sea change for churches, but is that accurate? Our chancellors on today's panel, Richard Hoskins, the Chancellor Emeritus from the Diocese of Chicago, and Tom Little, the Chancellor for the Diocese of Vermont, will tackle that question by exploring in more detail the history of the Johnson Amendment, the Texas litigation, the reach of the IRS's position, and the legal implications of that position on those who preach. Our cathedral deans on the panel, the Very Reverend Randy Hollerith from the Washington National Cathedral, and the Very Reverend Lisa Hackney James from St. James Cathedral in Chicago, will complement this discussion by exploring how to preach faithfully and responsibly in light of these developments. We know this issue is current, it's still developing, and that many of you may have important questions on your mind. We welcome those questions and ask that you put them in the chat. We will try and cover as many of those as we can in today's conference. So with that introduction and level setting, let's start with the background on the Johnson Amendment itself. I'll direct this question to Richard. The Johnson Amendment was introduced in 1954 by then Senator and later President Lyndon B. Johnson Why was it introduced, and what was the provision attempting to address?
Thank you, Aaron. Yeah, I'm happy to address that. And before we do that, a little bit of background even prior to 1954. Let me just say this about my remarks. You'll notice that they will be somewhat cautionary in tone, and that's because of a couple of things. One is there are certain specific limits to what's being proposed in the Texas litigation, and I think those limits have not been adequately understood by the press. And that's the other thing. There have been a number of misleading headlines from some journals which should have known better, mischaracterizing or characterizing too broadly what's going on in Texas. And of course, what that means is that what's going on in Texas has created a new level of uncertainty. And in periods of uncertainty or in topics of uncertainty, it's good to be rather cautious. And so that will be the nature of the tone of some of my remarks. It's also why I think Tom and I will both be talking maybe as I think the deans will, about prudential considerations as well as the legal ones. So let me turn to my PowerPoint slides, see if I can get them up here. Now, does that appear to everyone? Yes, okay. The first thing I want to do is remind us of the original Section 501c3 of the Internal Revenue Code as it was enacted prior to the Johnson Amendment. And you're probably familiar with it. Basically, it says that corporations are tax exempt, and not only are they tax exempt, but people who make donations to them, those donations are tax exempt if they meet the following qualifications. Number one, they're organized and operated exclusively for religious, charitable, scientific, testing for public safety, literary, or educational purposes. Second, they are, in fact, not-for-profit corporations. That is to say, no part of the net earnings inure to the benefit of any private shareholder or individual. And third, no substantial part of the activities of the organization is carrying on propaganda, that's what the statute says, or otherwise attempting to influence legislation. Now, that phrase influence legislation might raise a red flag, except that in subsection H of 501c3, actually it turns out that the requirement not to influence legislation is not terribly worrisome, because you have to not only be speaking to influence legislation to run into a problem, but you have to be spending a lot of money to do it. And most of our churches don't do that. So the original 501c3 is pretty straightforward. And that's the way it was until 1954. In 1954, Lyndon Baines Johnson was running for re-election to the Senate from Texas. As you know, he was re-elected. He then became Senate Majority Leader, actually, that same year, or in 1955, when the Senate convened. He felt that certain nonprofit groups, not necessarily churches, but others, were improperly campaigning against him in the re-election. So he proposed to add a new requirement for 501c3 entities in order to retain their tax-exempt status, and that is the amendment. It's a single sentence. Actually, it's not even a sentence. It's a subordinate clause, but we'll call it a sentence. Was adopted by both houses without debate, became part of the Internal Revenue Code of 1954, which was a new edition of the Internal Revenue Code signed into law by President Eisenhower. The purpose of the Johnson Amendment, as is pretty apparent from the language itself, was to prevent tax-exempt organizations from endorsing political candidates or otherwise, quote, participating or, quote, intervening in political campaigns. And so after the amendment was adopted, it became, in effect, a fourth requirement that tax-exempt churches and religious corporations and others had to meet in order to keep their exemption. That is to say, they not only had to be organized for religious purposes and be not-for-profit corporations, but they also had to not participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public office. As you can see right away, and as is so often the case with statutes, there's ambiguity in some of those terms. What does it mean to participate or intervene in? That's going to be the language that the IRS in Texas is going to use to suggest a reinterpretation of what it has been thought to mean prior to now. And of course, political campaign on behalf of any candidate for public office, that's certainly been thought always to include that you can't, name a candidate for public office and endorse or oppose them. But how much broader is it than that? That's always been a little unclear. We do have a few examples of what it means to participate in or intervene in such a way as to violate 501c3, but not very many. There's really only one case, and I think this is the only case that I've been able to find. I think it's the only case where the IRS has actually revoked a 501c3 exemption for a church. That was in a 2000 case out of the DC Circuit called Branch Ministries versus Rosati. It was a pretty bold case. Pierce Creek Church in Binghamton, New York, ran a series of full-page ads in the Washington Times and the USA Today 4 days before the election of 1992. That was the year that Bill Clinton was elected. And in the ad, they said, "Christians beware, do not put the economy ahead of the 10 Commandments." It asserted that Clinton supported abortion on demand, homosexuality, the distribution of condoms to teenagers in public schools. It cited various biblical passages and said Bill Clinton is promoting policies that are in rebellion to God's laws. And it concluded with the question, how then can we vote for Bill Clinton? So it's pretty egregious. That did result in an IRS investigation. And in this particular case, it actually did result in the church losing its exemption. As I say, it may be the only case. There have been a lot of investigations. Another example of an investigation that did not get so far, and this is more typical, was one that many of us are already familiar with, the investigation of All Saints Pasadena. After a sermon in 2004 during the presidential election, a sermon entitled "If Jesus Debated Senator Kerry and President Bush," and then went on to discuss the candidates and the platforms. The IRS opened an investigation, but quietly closed it a little bit later. But one of the points I will make later, if there's time, is, there has been significant under-enforcement of 501c3. If by enforcement we mean actually taking away the exemption, that has been extremely rare, maybe only one case. But if you're a church or a religious organization, it's not just the loss of exemption you fear, it's the cost and the distraction of an investigation, such as with All Saints, that may not result in actual legal results, but will be a real diversion from your ministry, cost you a lot of money hiring lawyers, cost you a lot of concern and anxiety, and those things, are good to be avoided as well. So that's where things stood after the Johnson Amendment was adopted in 1954. You all have been living with it, pretty clearly. As Aaron said in the introduction, President Trump has made it ever since 2016 or 2017, when he became president the first time, a stated objective that he wants to destroy the Johnson Amendment. And as Aaron said, he hasn't done that yet. That would take either an act of Congress or at least a public ruling by the IRS, neither of which has occurred. What has occurred is something a little different. In the United States District Court for the Eastern District of Texas, there was this lawsuit filed, which Aaron described, challenging the Johnson Amendment and its restriction against political statements or even political endorsements if they occur in the context of a church religious service, in effect. And what happened on July 7th, as you see here, was that both the IRS and the plaintiffs are the National Religious Broadcasters and a couple of fundamentalist churches in Texas, all the parties agreed to petition the court in a joint motion for the entry of a consent judgment that would modify the interpretation of the Johnson Amendment. Now, remember, let's just go back. The Johnson Amendment says you can't participate in or intervene in a political campaign on behalf of or in opposition to a candidate for public office, and that includes the publishing or distributing of statements. In paragraph 7 of the joint motion for the consent judgment, and by the way, the consent judgment has not yet been entered. It may be, we assume it probably will be, But the judge in that case has granted leave for Americans United for the Separation of Church and State to file a brief in opposition to this consent judgment request. So we'll see what happens. But the assumption is the judge is likely eventually to enter it, although he's not done so yet. If it is entered, it will provide in the proposed order the same language that you see here in the joint motion. It will provide that when, and these numbers have been added by me to make it a little bit clearer what the elements are, when a house of worship in good faith speaks to its congregation through its customary channels of communication, presumably that certainly would include the pulpit, perhaps other things too, newsletters or whatever, on matters of faith in connection with religious services concerning electoral politics viewed through the lens of religious faith. So those are basically the four requirements that if those are met, the IRS's position in that lawsuit is that that would not constitute either participation in nor intervention in a political campaign, and therefore would not violate the Johnson Amendment. That's the new interpretation. The ambiguities are even greater there, and we may talk about some of those, but that's basically the starting point. That's the language. Now, the important thing to remember is the limits of what's being done, and this is where the headlines have been misleading. So let's assume the consent judgment will be entered. It probably will, even though it hasn't yet. A consent judgment is simply a judgment entered by the court in a particular case that ends the litigation and binds the parties to its terms. But it only binds the parties to that particular case to its terms. And the IRS, of course, is a party. So it means that with respect to those plaintiffs, I think there are three of them, the churches and the NRB, the IRS would be constrained to construe the Johnson Amendment the way the consent judgment says they've agreed to construe it. It does not mean the IRS has to construe it that way in any other case against any other party. If there were to be a formal public ruling or a regulation by the IRS someday, published in the Federal Register that says this same thing, then that would bind the IRS in all similar cases and would provide protection to non-parties. But that's not been done here. So far as we know, that's not in the offing. It may be at some point in the future. And so the status, even once the consent decree is entered, is that the government may decide to apply a similar interpretation in other cases, but it also may not because it's not required to. That's why some of the headlines that I've noted here at the top of the slide have been kind of misleading. The National Law Journal, which ought to know better, says IRS enters into consent decree, limiting application. Well, they've not entered into the consent decree yet because it hasn't been entered by the court. Only a court can enter a consent decree. It is true that they joined a motion to ask the court to do that, and maybe that'll happen. Above the Law is a very popular blog from lawyers. Trump administration bones the Johnson Amendment. Not true. The only sense in which the Johnson Amendment has been boned is that it's been reinterpreted in one particular case for the protection of those particular parties. That's all. Religion News Service headlines, a little better. Churches can endorse politicians, IRS says in court filing. Well, those two churches involved in the Texas case can, and the NRB can't. And maybe the IRS will take the position that others can too, but they're not bound to take that position based on the Texas case. What all this means, of course, is that there's a clear and present danger, as I say at the bottom of the slide, a clear and present danger of selective enforcement. And I remind you what you probably don't need much of a reminder of. This is an administration, a presidential administration, that seems to enjoy doing selective enforcement. That is to say, enforcement of certain laws or statutes or interpretations in favor of their friends, but against their enemies. And the IRS is still free, even if the Texas consent judgment is entered. They're bound by it there, but if they decide that other churches, different from the churches in Texas, are engaging in things that are not pleasing to the administration, then they're free still to apply the Johnson administration through a different interpretation. Now, if that were to happen, certainly the target of that enforcement action would remind them of what they said in Texas, but they would be able to say, yes, that was true in that Texas case, but it's only true in that case. And that's the main reason for the cautionary tone of what I'm saying. It's not binding with respect to other churches. And one can imagine that a political sermon in an Episcopal church might be looked at differently from the White House than a political sermon in, say, a Baptist church. It may not, but it may also, and there's some concern and fear about that. All right, that's essentially what I wanted to say. I've got a couple of pages of bibliography at the end, which we'll post that with, if you want to read some of the articles about it. But now I think that's the background, and let me turn it back to Aaron to have others now comment on some of this, and I will stop the screen share.
Thanks, Richard. That was obviously very helpful background. Just a quick question to you and to Tom. Do we see this IRS position as actually being different than has been taken in the past? Or is this really maybe the first time that the IRS has specifically commented on the Johnson Amendment in relation to religious speech?
Well, we can certainly say that if this had been the interpretation at the time of the investigation into All Saints Pasadena, the investigation probably would not have occurred. Because this interpretation, which says, that was a sermon from the pulpit to the congregation in the ordinary course of religious services, precisely the kind of speech that this reinterpretation would say is permitted under the Johnson Amendment. Under the Johnson Amendment. That was not the position of the IRS at the time. So, yeah, I think we can say that it's been treated differently in the past. Tom, would you agree?
Yes, and if you go onto the IRS website and look for its official position on this issue, what you will find is an endorsement or agreement with the result of the Branch Ministries versus Rosati case that Richard mentioned. And it goes on to say the court rejected the plaintiff church's allegations that it was being selectively prosecuted because of its conservative views. And quotes from the court, quote, "The government has a compelling interest in maintaining the integrity of the tax system and in not subsidizing partisan political activity, and Section 501c3 is the least restrictive means of accomplishing that purpose." Now, this page was last updated on May 29 of 2025. So you might say that's the IRS's broader official position, but the evidence from this East Texas case, I think, points to where it is heading or has pivoted to.
So in light of this development, and I'll turn this over to Lisa and Randy, what does it mean to preach in this moment? I'm particularly curious about what the lens of faith means. That is language that the IRS used or has proposed for the consent decree. From your perspective, what does that lens of faith mean?
Lisa, you want to go first?
Well, yes, Randy and I are out deferring one another. First of all, thank you to our chancellors for coming on. The headline that you missed, Richard, because you are reading fancier magazines than I am, you missed the headline from the New York Times that said, IRS says churches can endorse candidates from the pulpit. Where my eyebrows went all the way up to my hair and back down. And I'm like, oh my God, what is that going to do to our life in the church? So that's an alarming. And for the preachers out there, we see you in the chat and know that you're coming from lots of places. I've been preaching for just a little over a couple of decades now, and I don't know about you all, but the Johnson Amendment has lived in my head rent-free this entire time. Partly because one of the first sermons that I preached as a curate back in 2004 was in the wake of the hearings on Abu Ghraib. And I said something very mild because I frankly, was a very new preacher. And I just said, something about the Gospel of John that says Jesus is from God and we're from him and we're all together. And I said, so you look at this terrible thing that's happened in Abu Ghraib, and our soldiers are out there and treating these people in Iraq this way. And so for better or worse, the soldiers come from us, and they're there, and they're the face of America. So wherever it comes back up, how far up the chain it goes, we need to fix this so that with the face that represents us is the face of a bunch of Christians, or something quite basic like that. And boy, at the end of that sermon, it was in the spring of 2004. And so someone came and yelled at me and said, it's illegal for you to preach that. You're not allowed to preach politics from the pulpit. And how dare you preach something like that during an election year? And I was just astonished at the strength of the response. Now, I have since learned to preach in ways that aren't quite so direct and get the same point across. And I actually want to invite you, Randy, to speak about, because I think you express it so eloquently, and of course you live in the space like none of the rest of us do, being in the position where you are. So I think I would just say that the alarm I felt when I saw that headline, I feel much comforted by the input from our chancellors. But Randy, if you'd pick up and just talk about how you look at these worlds coming together.
Yeah, thank you, Lisa. And I really appreciate the work that's being done here. I think this is an important conversation to be having. I was part of that clergy group in 2017, standing around with the newly elected president right before his inaugural service at the cathedral, when he started talking about the importance of getting rid of the Johnson Amendment. And I have to be honest that I was there with a number of bishops. We were just greeting the first family as they arrived at the cathedral. None of us knew what the Johnson Amendment was at the time, and we were walking the president upstairs to seat him in the cathedral, and I was Googling on my phone at the time, trying to figure out what the Johnson Amendment. And we were all rather, in conversation later, we were all rather shocked that he would want to get rid of this the statute that prohibits, the way we understood it, prohibits people from naming a candidate and telling people to vote for a certain candidate from the pulpit, which is how we took it, and thought it would be horrible if that, quite frankly, if churches were given permission to do that. At the same time, I've always quite understood that the gospel is political in and of itself. It doesn't need to be partisan, and I don't think it is partisan. In fact, I think if your God looks too much like your political party, I think you're probably got God wrong. But I do think that preaching the gospel often has political overtones, and I've always seen the Johnson Amendment as prohibiting the naming of a candidate from the pulpit for election, and the sort of encouragement of one's flock or the congregation to vote for that person. As far as preaching something that has political overtones for something that an administration is doing or failing to do, I always say that the most important thing that we have to do is to stand by the values of the Christian faith. And in the context of preaching about values, I think sometimes we must or are pushed in a direction of having to make some sort of theological commentary on current events. I think our preaching, that's important for our preaching to be authentic, quite frankly. And I think it needs to be done carefully. But what I see as far as this amendment goes is it says to me that pretty much if the administration wants to come after a church, if the IRS wants to come after a church for something it said, they've got lots of leeway to do that. Lots of leeway to do that, the way the statute's written. And I think we all run the risk that that could happen. I know we certainly run the risk here at the cathedral that might happen. That was made fairly clear by some following the inaugural prayer service for the second term of the president. So, I always say, preach the gospel and let the rest chips fall where they may.
Randy, is there a difference in your mind between a preacher being political and being partisan? And if there is a difference, sort of how does that manifest itself within the context of preaching?
Yeah, I think there is a difference. I mean, I think the question is what's driving my preaching? What's driving the preaching? Is it a response to the teachings of Jesus, or is it my own political leanings, right? Am I doing the work of proclaiming the gospel, or am I doing the work of political reflection that can happen anywhere in the newspaper or on television? And I like to hope that what we're all pointing towards is trying to reflect on the gospel and the values of the gospel. But sometimes in our world, when Jesus says, love your enemies as yourself, or love your neighbor, that has implications that sometimes get played out in our preaching. And I think that's appropriate.
I would jump in and add, I see that Claudia Vayek has a question in the chat saying, how do we square the strong support of the Episcopal Church during the Civil Rights Movement and its stand against the Vietnam War with the current interpretation of the Johnson Amendment? I'll let the chancellors respond to the second part of that, but I will say this as a person who spent 10 years in Cleveland and a good part of it doing some significant community organizing. It is and I learned through the IAF method and with great teachers there, but it is no accident to your question, Claudia, that the civil rights movement utilized the infrastructure that is already inherent in the churches. Because when you're trying to organize to bring change about, which is slightly different than advocacy and voice, if you are actually trying to bring change about, you need to build power. And if you're going to build power, what is power? The most basic definition is organized people or organized money. Either of those works. If you have both, it's great. And in fact, churches are a network of already constituted organized people and organized money. So there is a reason that the church has an infrastructure that can help us in moments where our society needs to change. I will also say in another principle in organizing that I learned was that if you're building power, you want the most people with you. And the minute you stake out a position, a political position, doesn't matter if it's on the right or the left, you're going to lose people. You're going to lose and you're going to reduce the power that you have. So part of the art of it is to keep the ceiling high enough and the tent wide enough of the people that you're gathering around the interests you're gathering, so that you do have an ability to move with intention, with focus, and with impact. And you don't get that by frittering it away on, as Randy said, me getting up and saying, I'm feeling really vexed about this or that issue, and let me just go to town on it. You're going to work against your interests if you let that take precedent over your strategic organizing.
Aaron, can I add something to that?
Yes.
Two things. State the obvious. It makes a difference which administration is in power. So we're now in a period for the next 3.5 years where an administration is in power that does engage in selective enforcement more than previous ones, and that has a more conservative bent than some previous ones. So, the question of what you can do safely is going to depend quite a bit, really. More on the civil rights question. I think those would be safe, probably even now, for a couple of reasons. One was, take the civil rights movement led by Dr. King. Fortunately for this purpose, he was not running for public office. He was a minister. He was an advocate for the poor. I don't think there's much risk in ministers or preachers talking about the civil rights movement. And a second thing that is I think helpful about the civil rights movement is the broader the issue, to some degree, the less danger there is, right? I mean, not only was Dr. King not running for public office, which helped a lot because it was not an electoral thing, but second, the civil rights movement had a lot of different aspects, only some of which concern the law. And so, one could from the pulpit talk about the good things about the civil rights movement, the need to protect the underprivileged, the need to look after the rights of Black folks and poor folks. without thereby getting into specific issues. And indeed, a preacher could even say, and I realize the preacher could say, that there are various political aspects. You could disagree with some of Dr. King's tactics if you want to, that's fine. But my point, the preacher would say, is that we ought to be attentive to these issues that he's brought to our attention. So I think there's cautionary language or there's framing language that can be used that makes one even more likely immune from too much danger, even in this administration. In other administrations, I think it clearly would be true. Similarly, the Vietnam War, it was maybe more political, but again, you didn't have somebody. Now, if it was in the context of a presidential election, then you have to be more careful. If it were a matter of, the protests against the Vietnam War and so forth, again, that's more of a general phenomenon with many different aspects, and I think there's some safety in that.
Aaron, let me just add or echo what we were talking about a bit earlier, and it's what we still don't know. Richard presented a slide that shows what the parties put into their motion for the consent decree, and it's not very well written, in my humble opinion. It raises more questions than it answers. We don't know yet what the text of the proposed consent decree is, and I hope, for the sake of clarity, that it is the judge takes that and does some work on it, perhaps as the result of reflecting on the amicus brief that is being filed. Because, for example, speech concerning electoral politics in the context of worship services, lens of religious faith, customary channels of communication, house of worship in good faith. Those, if that's what comes out of the court's order at the end of the process, that's going to raise a lot of questions and not provide all that much clarity. And I think that would be a disservice. And I'm hopeful that maybe I don't have a lot of grounds for hope, but that even if we don't agree with the outcome, that at least the outcome has got clear language.
That raises a question in my mind, Tom, about whether sort of the use of the language electoral politics suggests, if it does end up in the consent decree, does that really suggest that someone from the pulpit can endorse a political candidate, or is that still going to be off limit? It's an interesting use of terminology, right? Electoral politics really does suggest an election of some sort. So how do you interpret that?
It would have been very easy for the motion to say churches can endorse candidates from the pulpit. We understand that, and that's what many people in the regular news media and in social media have immediately jumped to, and that may well be the intent of the lawyers working for the IRS, and they wanted to couch it in different language, so it didn't look that way so boldly. Time will tell. I think it could take another. Richard, what do you think? Months?
I think if this language were to be part of an IRS ruling that binds them nationwide, then yes, I think pretty clearly the ability to speak concerning electoral politics viewed through the lens of religious faith would permit you from the pulpit to endorse or oppose a candidate. I think that's clear. Of course, we're not there. This is just a consent judgment once it's entered that provides protection for the plaintiffs in this case and nobody else. But yes, if this were to become the national standard, I think it probably would permit that. Now, whether that's a prudent thing to do, because I really agree with much of what Lisa said, but this is, for you ministers to decide. How much do you want to risk alienating people by preaching to them about things where they might wish you wouldn't be so specific in directing them? That's a different kind of prudential question, but legally, I think it would be permitted if this were the national rule, which is, yeah.
So I understand that a number of bishops in the Episcopal Church have made it clear to that preachers in their diocese may not endorse a particular candidate or political party. I want this goes to some extent to the earlier question that Lisa addressed from Claudia, and I'll tie it to Bishop Rowe. He has said that we as a church are an engine of resistance. And that had its sort of own, had some political overtones to it. Are these positions at odds? Sort of how do folks that are preaching, how do they sort of reconcile all of this? Maybe I'll direct this to Lisa or Randy. What are your thoughts on sort of the church's position?
Well, a couple of things. I think there's a significant difference between actually endorsing a candidate for the pulpit and being an agent of resistance, or whatever the language was Bishop Rowe used. The former is a very partisan issue. It seems to me a very political party issue, whereas the latter can be seen, and I certainly would understand it as, look, if there are things that are going on in our country that are considerably violating what we consider the basic moral premises of what it means to be a Christian, then we need to push back against those things. But that would be regardless of who's doing those things, whether that person is one political party or another. The issue is not the party. The issue is the action. The issue is the value that's being misused, mistreated, or the immoral action that's taking place. At the same time, we talk about the strong support of the Episcopal Church for civil rights, but we also ought to remember there were a lot of silent pulpits during civil rights in the Episcopal Church where no one spoke up. So, which also raises the issue of sometimes one has to think about how many people are going to hear, depending on how I preach a message, how many people are going to hear it, or how many people are going to automatically turn it off if it's not done thoughtfully, carefully, with compassion in how things are delivered. Because I think our preaching is only as good as people can hear us and are willing to trust us and to listen.
And I'll just amplify what you said, Randy, and also to pick up on that. One of the things I've learned over the years is that the pulpit can actually not be the right tool for meaningful discussion and exchange. That and like you said, Randy, if I sometimes just a word like healthcare or something like that, people, if that's an issue that's out there, the ears slam down shut. You can see it on the faces. And to your point, if you can't have the conversation, or if you can't deliver the message, if it can't be received, it's not really an effective sermon. So to remember as preachers that there are certain things that are better done in conversation. And I see Marina over here is asking about where is the moral conversation? How do we have conversations about difficult, divisive, and polarizing topics? I think one of the things is in some ways the pulpit is the least effective place for us to bring that into the conversation with the whole body. And I will also just say, while I have the floor, the other thing that I have reminded myself over the years about is that I'm very, very attentive to the Johnson Amendment. I came to priestly ministry when they were going after All Saints Pasadena. So I've really paid attention. It's been there this whole time. But I also remind myself from time to time about this bigger moral question, which is Jesus did not call us to be perfect implementers of a perfect nonprofit strategy and to remain within the guidelines of the IRS. If there comes a day where we as the church collectively, or any of us as preachers individually, it's worth reminding it's not actually illegal to say any of the things we're talking about. What it does is it puts our institution at risk in all the ways that Richard mentioned at the beginning, not only losing our tax status, but other kind of engagement with the IRS and the law. But at the end of the day, we we are not called, we are called to preach the gospel, as Randy said. We're called to preach the gospel, as Jesus said, and we're called to that first and foremost. And so at the end of the day, there may be a time when the church has to say, look at each other and say, okay, so we can't have our tax status. Can we actually run a church? Can we sacrifice enough to be the church, even if we can't deduct it from our taxes at the end of the year? Just another, I'm not advocating we go there, but just a reminder that this is not like bound hands. We still have freedom of speech in this country.
And to Marina Buehler-Miko's comment and concern in the chat, and responding to Jim Coleman's as well, turning back to the language in what has been proposed to the judge, it is concerning electoral politics, not politics more broadly writ. And there clearly would be some significant gray area there, but if someone is preaching about a political issue, the war in Vietnam or the war in Gaza, for example, and not using that as a way to attack or support a particular political candidate, it wouldn't be triggering the specific legal issue and doctrine that we've been talking about as a general rule.
Yeah, Jim, thank you for your comment in the chat. It led me to have a similar thought, Tom, as you were just explaining, that there is a difference between talking about things that are, or preaching about things that are political and endorsing a political candidate. And that is a distinction that is still important. And something to keep in mind, because the consent decree does talk about, and we mentioned it earlier, this lens of faith, right? That if you're talking about political issues to your congregation, you are preaching about those political issues through a lens of faith. That is a permitted activity for purposes of your 501c3 status. So just because you're talking about gospel text in a way that implicates a political issue, that is still fair game and has always, I think, been fair game, and doesn't pose a risk to your tax exempt status. Richard and Tom, do you agree with that assessment?
Yeah, I do. And referring back to what I mentioned earlier, I think to the extent you even get close to electoral political, in other words, if you're talking about political issues and it happens to be election season, which in this country seems almost endless, but suppose it's 3 months before the election. So I think we all understand that if you're approaching an election, then even if you don't talk about candidates, people are likely to ascribe political motives to you much more than if you're 2 years away from an election, right? But even then, I think if one wants to make a political statement, not naming a candidate, but where it's fairly apparent that one candidate agrees with you more than the other, even there, I think one can use framing language that's protective and also, frankly, prudent to say, look, there are a lot of reasons why one ought to vote or not vote for a particular presidential candidate. And we don't encourage one issue voting, but this is an important issue. And we think as Christians, you should reflect on this issue in the following way. And I think that kind of limiting framing language is also helpful because, again, you're not directing people, even indirectly, to vote for or against a candidate, but you are asking them to consider one issue that is presumably part of the campaign and to consider it from a Christian point of view through the lens of faith. And I think that should be fairly safe, even if you're not protected by this particular consent order.
And Randy, I'd like to direct this to you, and it ties to Evan White's most recent comment in the chat. Richard talked about sort of some guidelines or other things that you can put into place with respect to your sermons and preaching that will avoid some of these issues. Do you have any other suggestions for the preachers? And is there something or anything concerning or unique about the prayers of the people, who you include in it, what issues you might be addressing in the prayers of the people that should be taken into account?
Let's start with the latter, I think. The prayers of the people, I always find to be a tricky situation anyway, but I think the prayers of the people ought to be focused on God and not on trying to make a statement in one way or another. I think we end up doing a disservice to our spiritual life in the church, and I know that sometimes we fall into that here at the cathedral. So I'm not saying I'm immune to it, but I think we do a disservice to the heart of what we're supposed to be doing in a Eucharist on Sunday morning when we're trying to prove some sort of point or make a point through the prayers of the people, other than just genuinely wanting to pray for X, Y, and Z. So I put that out there. As far as the preaching goes, the rule that I make is I never make it if my sermon has got some political overtone to it, I never make it about a person. Once again, I always make it about a value. So I'm not going after a person or what a person has done. I've never preached a sermon about a president or a congressman or a senator or anything like that. It's always been about a value that can, be very broad, quite frankly. So my basic rule is when I get up in the pulpit, I don't talk about a person. I don't make it about people. I make it about values. And I also understand, that a lot of us work in purple parishes, right? Where we have folks on both sides of the aisle. And once again, our preaching is only as effective as we can bring others along with us. And I think Lisa's absolutely right. I think it's really important to figure out where we ought to say what we want to say. Do we say it in the pulpit, or do we say it in a conversation we're having in an adult forum where other people can take part, or do we say it in a newsletter piece that you're writing? And then I think picking the right avenue to express ourselves is important as well. And giving people that space for conversation is so critical, because when you're in the pulpit, nobody gets to answer you, right? They just they're trapped there with you as you offer what you have.
There's a comment or question from Daniel Galbraith in the chat about preaching about specific legislation. And in Richard's slide presentation, he covered that subsection of the Internal Revenue Code, section 501C3, and the law as it's evolved around that piece makes it clear, we think, that that kind of legislative activity has to be very focused and have a lot of impact over a significant amount of time. It's like, in a sense, almost hiring a lobbyist or being a lobbyist in the halls of a state legislature. But preaching about a particular pending piece of legislation, again, particularly if done in the manner that Dean Hollerith is speaking about, I think is fine.
Yeah, I agree with that. And you just to be prudent, again, you're never going to present even an attack on legislation as something where you're handing down on high as if you were Moses the right answer. You're going to be provoking people to think about it from a Christian point of view, because you want to be persuasive, and to be persuasive, you don't want to sound like God, because you're not God. Certain issues that you think the gospel itself causes you to raise. So, you do it in a certain way, and I think that is the point of both the deans, and I think that's the key.
And what about activities sort of outside the pulpit? Churches that get involved in protests, for example, or some sort of activism that may be tied to their social justice ministry. One, does this consent decree, does this IRS interpretation that we've been talking about, does it address that? And if so, what are some lessons that we should take away from sort of what the impact of that interpretation may be on those activities?
I'd make 2 quick points. One is, I think that for most purposes, and I'll come back to what I mean by most purposes, that engaging in community activity of that should continue to be fairly safe and should not present undue risks. Now, the only exception to that is the point I made about this particular administration, which does engage in selective enforcement. And so I can imagine a case, I don't think it's likely, but I can imagine a case, and it's not outlandish, where this administration, the IRS or someone else in the government, might use the Johnson Amendment, 501c3, as a way to threaten you as a result of participating in community activity or protests or things of that sort. That would be unprecedented, but it's not out of the question in this particular administration, so one has to think about it. I don't think one, though, has to think about it so much that you don't do it. I mean, I really think that's a stretch. And if there is to be a change of policy by the administration with respect to things like that, I think there would be some indication of it in advance. And so I think we should continue to participate the way we continue to do it. I just don't see a great risk there.
Well, with our last few minutes, I thought maybe I could just turn it over to the panelists if there's any final comments you want to share, whether they're sort of legal observations, practical observations, or guidance you want to share with folks. Maybe we can start with Randy and then go to Lisa, and we can end with the chancellors.
Well, I think I've talked too much, quite frankly. So what I'll say is that I'm really grateful to EPN for putting this together. I think this is a really important topic, and I think it's going to become more important in the years to come. So I think making us alert to this and paying attention to it is really important for all of our ministries. So thanks. I'm grateful to the group here gathered together as well, and grateful to be included. Thank you.
Thank you, and I'll just jump in and echo your gratitude, Randy. Thank you for that. I'm also just going to lob this in here for the priests out there and the deacons, the folks who report to a bishop. I think one kind of fun tidbit about all this is that when the bishops have kind of come in and responded and said, we're giving a pastoral directive, that actually impacts us more than just this kind of vague threat out here of the Johnson Amendment being enforced or not enforced. So I think that's been an interesting facet of the way this is unfolded, and I think that's another thing for us to watch and to be reminded that actually we can roll the dice with the IRS, but there's no rolling the dice with our bishops usually. So be aware of that.
I'd add just briefly, ditto. The court case is not looking at different church polities, and the Episcopal polity is one where we could probably have 2 more seminars on that in the context of this case. But just we all need to be mindful of the polity of our church, which is not always easy to discern. I'll leave it at that.
And I'll just say I'm grateful for the opportunity to participate too. I think conversations like this are useful, and I hope we've been helpful.
Well, great. I think that brings us really to the end of our time. I believe we addressed the questions that were in the chat, but if any of you have follow-up questions after you've had a chance to digest the webinar, feel free to reach out to the panelists and ask those questions. Or I'm offering your time, everyone. I assume that's okay. And I do think it's important to remember that this webinar is being recorded. It will be on EPN's in their online and available for anyone. You can share it with others, listen to it again, sort of react to it as you need to. There's a lot of other really incredible content on EPN's website, webinar recordings from past webinars as well. So I encourage you to take a look at that and find other resources that may be helpful to you and to your churches. And with that, I think that brings us to the end of our time together.